C-SPAN friends, welcome to the next installment of the National Constitution Center and C-SPAN's Supreme Court Review Live. I am Jeffrey Rosen, the president and CEO of the National Constitution Center, which is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people on a nonpartisan basis. It has been so exciting to partner with C-SPAN during these historic weeks when, for the first time in American history, the Supreme Court is broadcasting its oral arguments live. We've all been listening closely to these two important cases this morning. There's been so much to learn and unpack, and we're very fortunate to be joined in both cases by America's leading scholars and advocates who have filed briefs on both sides of the case to help us understand the arguments that we've just heard. We're going to begin with the Little Sisters of the Poor case, which was the first case that was argued. And it's with great pleasure that I introduce our two panelists. Helen Alvaré is professor of law at Antonin Scalia Law School, George Mason University, where she teaches family law and religion and property law. She has written many books, including Putting Children's Interests First in American Family Law and Policy and the Conscience of the Institution. And she filed a brief in support of Little Sisters of the Poor, who are the petitioners, on behalf of women scholars. And Louise Melling is Deputy Legal Director at the ACLU and Director of its Center for Liberty, which encompasses the ACLU's work on reproductive freedom, women's rights, lesbian, gay, bisexual, and transgender rights, freedom of religion and belief, and disability rights. She has been with the ACLU since 1992 and has written many articles about, including those about religious refusals to public accommodations laws. And she filed a brief in support of the state of Pennsylvania, who are the respondents, on behalf of the ACLU. Helen and Louise, thank you so much for joining.
Thank you. Nice to be here.
Well, there's so much for us to discuss. Helen, we'll begin with you because you filed a brief on behalf of the respondents. They were represented before the court by Solicitor General Noel Francisco. And what would you like to tell our C-SPAN listeners about what the core statutory and constitutional arguments in this case is about and what General Francisco was arguing?
Yes, he was arguing that in fact, the Trump administration's agency, Health and Human Services, had the right, he would say the duty, to exempt religious, and they also exempted moral objectors to the contraceptive mandate that came out of the Affordable Care Act. Some people call it Obamacare, way back when. And the state of Pennsylvania is claiming that the Trump administration did not have the authority to grant these religious exemptions, that the language of the healthcare law gave a very narrow delegation to the agency, very narrow, and it basically said, you have got to provide the preventive healthcare services that are named by the what's called the Health Resources and Services Administration, a part of HHS. Noel Francisco says, wait a minute, first of all, every single federal law has to be carried out in coordination with the Religious Freedom Restoration Act, which conditions every single federal law and requires them to comport with respect for religious freedom. The government can only burden religious freedom if it has a compelling interest. So he said the agency always issues regulations with an eye to what federal law requires. Second, he went into some really detailed language about the Affordable Care Act and said, it says that they provide Health Resources and Services Administration can decide what forms of preventive services it provides and supports. The Trump administration decided that it provides and supports contraception, but that it has to exempt religious entities. The final point on this, which was really interesting to me, is that Pennsylvania comes back, and Francisco responds to this at the end when he can. Pennsylvania comes back and says, well, we have to grant exemptions for churches. And Alito said, yeah, but that includes people like people who clean churches or secretaries there, who you don't think are constitutionally mandated to be exempted. So you don't really believe what you're saying. You know that HHS can give exemptions broader than simply what the Constitution mandates. So that was the main back and forth.
Thank you for explaining that so well. Louise, we heard arguments from the state of Pennsylvania, and just to review some of what Helen just said, in 2013, the federal government exempts churches and other houses of worships from the contraceptive mandate of the Affordable Care Act. A year later, in the Hobby Lobby case, the Supreme Court said that a corporation owned by a religiously devout family with sincere objections is allowed to opt out of the mandate. Then in 2016, there was this challenge by religious nonprofits, including the Little Sisters, who said that even telling the Health and Human Services Department about their objections placed a substantial burden on the exercise of their religion under the Religious Freedom Restoration Act. And the Supreme Court sent that back to the lower courts to try to work out a solution. And this case is about the regulation issued by the Trump administration, new rules that expanded the exemption from the mandate to include a moral objection and allowed private employers with religious or moral objections to opt out of providing coverage without any notice. And Pennsylvania and New Jersey wanted to block the rules, saying they violate both the Affordable Care Act and also federal laws requiring administrative agencies not to act in an unreasonable way. So with that procedural background, how would you state from the perspective of Pennsylvania and New Jersey, the main issues in the case and why they believe that the government lacked the authority to issue these regulations?
I want to focus on a point that came up in the argument, and which is one which we firmly believe needs to be front and center, which is what I'm going to call third-party harm. And for purposes of that, I want to step back. I want to step back to where we were before the Trump administration issued these new regulations. Before these new regulations, nonprofit entities, as well as closely held for-profit entities that had a religious objection, could say, I object. They could say this to the government, and then the government would notify their insurers and work with the insurers to make sure that the insurers provided coverage. What's significant about that was that what we call the accommodation was designed with an effort to respect the religious views of those institutions that objected, while continuing to ensure coverage, contraceptive coverage, the purpose of the statute at issue here, to the women who were to be the beneficiaries. And both in Hobby Lobby and in Zubik, the court made a point of emphasizing that the provisions that they were discussing meant, Justice Alito said in Hobby Lobby, we think there will be zero harm to women if we open up this opportunity for the accommodation for closely held for-profits, as well as objecting nonprofit entities. And in Zubik, when the court sent the matter back down to say, the court said, kind of, can't you look at this and find a way to both address the religious objections as well as to ensure that there's still continued coverage? What was interesting about today's argument, rather than focusing on New Jersey and Pennsylvania, I'm going to focus on the chief. The chief asked more than once during the argument, isn't there some way to think about this that respects both interests? The chief in those questions, like Justice Ginsburg, although Justice Ginsburg, much more assertive about it, was talking about trying to ensure that the very purpose of this benefit would be respected, that women would still get the benefit. The question here, I think, the critical question as I think about it is, under the new Trump rules, can you be required to pay for your employer's religion? Can the government legitimately say, we're going to exempt you and have your employees are going to pay by being denied a benefit that they're otherwise entitled to by law, so as to accommodate the religious interests of your boss?
Thank you for putting the case starkly, and also for uniting questions that, as you suggest, both Chief Justice Roberts asked repeatedly, and then that Justice Ginsburg put even more pointedly. So just to review what those questions were, Chief Justice Roberts said prior cases struck a balance. These rules exempt employers altogether if they had no objection to this exemption, and allow publicly traded companies to claim the exemption even if no company requested them. And then Justice Ginsburg, several times in that very dramatic moment, we know that she is participating from the hospital, and our thoughts and prayers are with her. She was at the height of her powers, and she said the glaring feature of what the government has done in expanding this exemption is to toss to the winds Congress's instruction that women need and shall have seamless, no-cost contraceptive coverage. This leaves to women to hunt to other government programs that might cover them. They can get contraceptive coverage only from paying out of their own pocket, which is exactly what Congress didn't want to happen in this area of religious freedom, where we have a tolerance of accommodation and respect for workers and students. And it was she went on at quite some length, and she said, you've just tossed entirely to the winds what Congress thought was essential, which is that women be provided this service with no hassle, no cost to them. Instead, you're shifting the cost of the employer's religious belief onto these employers who do not share this religious belief. I did not understand RFRA, that's the Religious Freedom Restoration Act, to authorize harms to other people, which is evident here. The women here get nothing that they're required to do, just what Congress didn't want. Helen, that was a long question, but what is your response to the questions of Chief Justice Roberts and Justice Ginsburg? Chief Justice Roberts, can't we find some reasonable accommodation? And Justice Ginsburg, why are we imposing all of the costs on the women?
There was so much more on this in the briefs than there was in the argument, so I expect it'll be in the opinion. The first thing is that the people who originally made the exemptions was really Congress and the Obama administration. So she wants to talk about people tossing things to the wind. The Obama administration already granted exemptions for, religious churches, dioceses, for individual orders of religious clergy, et cetera. And it was Congress that already exempted grandfathered plans. So already millions and millions and millions of people were not required to cover contraception. So Congress did say that grandfathered plans had some minimum requirements, like, the 26-year-old age limit, et cetera. But it was Congress and the Obama administration that so-called tossed that to the winds in the first place. The Trump administration merely added on to the Obama administration's, making it easier to get what Louise properly calls the accommodation. As to the question of third-party harms, that's a really interesting, new, and controversial question. It was addressed partly in Hobby Lobby, and it was actually a back and forth in the Hobby Lobby oral argument. If it is possible for the government to say, okay, people, religious hospital, you have to perform abortions. All right, nursing homes, you have to do assisted suicide. And then if they refuse, we interpret that as third-party harm, right? Every time we refuse to bow before a government mandate, they can turn around and say, you're forcing people who voluntarily were employed at your organization to bow to your religion, even if they don't agree. That means there is no federal mandate that could stand the test of the non-establishment clause. Because every time someone would refuse to obey it, the argument would come, it's third-party harm. The Establishment Clause prohibits coercing people to practice your religion. The Establishment Clause does not prohibit accommodations. The government has allowed accommodations since the beginning of the religion clauses. Hobby Lobby picked up on the point I just shared with you, which is that it would be ridiculous to say that every objection to a government mandate by a religious practitioner equals a violation of the Constitution, or no accommodations would ever be permitted. And that's just not historically or legally true.
Thank you very much for that. Louise, Justice Breyer asked a really pointed question, which is, he said the point of the religion clauses is it works out accommodations. These are among the most difficult disputes. But I don't understand why this just can't be worked out. And if it can, why is this the right legal box? Isn't the question whether this particular rule is arbitrary, capricious, or an abuse of discretion under the Administrative Procedure Act? The religious groups say they had a religious objection. On the other side says that women's and taxpayers will be hurt. Their interests on both sides. The question is whether it's an arbitrary or an abuse of discretion. Why shouldn't that be the right standard?
I would not say that I'm an APA expert, but what I can say is that in this case, there were other arguments available, right? The question in the case was really then turning on, what is the authorization for this particular rule? And I just want to go back and be clear, because I think what's not totally clear is prior to the Trump rule, it was the case that if employers said they objected, they told the government, and then the insurance company under the accommodation then provided the benefit. You still got a seamless, no-cost benefit. This isn't a question of just expanding an exemption to cover for-profit institutions. This rule completely changed what the norm was, in the sense that the norm previously was to cover third parties. So, and the objection in the prior case, one of the core questions here is, so what was wrong? That's sort of what some of these questions were. What was wrong with the prior rule? And was the prior rule, in fact, a violation of RFRA such that you had to go to a proposition where you, rather than having somebody say, I want out, and then the government and the insurers took care of it, that now you would say, I want out, and my employees are out too from getting the benefit. And the question in the case, I mean, the case could have been teed up as arbitrary and capricious. The case is teed up as, is there authorization for this particular way, both a religious rule, a religious exemption, and for the first time ever, a moral exemption? Are those authorized by the ACA? Are they required by RFRA, or are they authorized by RFRA? What I thought was kind of interesting was, I don't think, I'm trying to remember, I can't, there was little talk about whether they were required by RFRA. That argument wasn't really advanced, which was surprising to me in some ways. The argument was all about whether it was within discretion, not whether it was required. And I think that makes it more significant even when you think about the harm, right? Do we have the authority under a rule that was meant to provide a benefit, a non-discrimination rule to my mind? Do we have the authority then to exempt out the people who are supposed to be the beneficiaries if we're not otherwise required to do that?
That's really helpful. And just to make sure I understand it as well, a dispute was, does the original statute, the Affordable Care Act, authorize the delegation to the agency to make this rule or not? And if it does, then courts can choose to defer to the rule if the delegation is broad, said Justice Kavanaugh. But if the statute did not authorize that delegation, which was narrow, then courts should not defer. And part of the dispute was whether or not that language of the original statute authorized the delegation in the first place. Helen, how much of the case will turn on whether the justices view the statutory language as being a broad delegation or not? And what do you make of the fact that the more conservative justices, who are often skeptical of broad delegations by Congress to the agencies, here seem to be arguing that the delegation was broad, and the more liberal justices seem to be arguing that it was narrow?
Yeah, first of all, I agree with Louise. I too was really struck by how much of the argument was about whether HHS could do it versus whether the Religious Freedom Restoration Act, required it. So that was really interesting to me. But in any event, it was the case here that you had who are considered the sort of strong, first free exercise protective justices, the supposedly more conservative, wanting to grant broad delegation to an administrative agency, and justices considered more liberal, wanting to have very narrow delegation to agency, completely against type in the legal world. The question, I think a lot of the opinion, because of how much of the argument turned on it, will go to the question of delegation by Congress to the agency. But I have to say, the practice of Congress delegating to HHS decisions about medical things, and then HHS goes and it contacts some outside expert institution, is so very common that I would think this would be very common also. Second, the question of whether you can make religious exemptions to some broad HHS statement about what will and will not be provided medically. Gee, that also has been done innumerable times in the past with religious exemptions. We have the tradition on, abortion in particular, also contraception and sterilization. And then I think so interesting also is the question of the actual exemptions that were already given by the Obama administration. They already said, oh, well, we could never have churches or religious orders having to do this. Well, if the Obama administration was permitted to make a religious exemption for some, but not all religious institutions, then why can't the Trump administration? And I think this was the question on which the attorney for Pennsylvania was mostly caught on the edge of a pin by Justice Alito, who said, you've admitted it's okay to make some religious exemptions, why not others? He says, well, the First Amendment commands some of them. And he goes, doesn't command everything that the Obama administration did in your view. So I found that a really interesting exchange.
I'm so glad you noticed, you picked Justice Alito's exchange. I found it really interesting too, and I want to ask Louise about it. Justice Alito said, you say that this accommodation was required to comply with the First Amendment church autonomy doctrine. He said, take a woman who works for a church in a secular capacity, a woman who cleans the church property. Under your understanding of the religious autonomy doctrine, does that mean that the employment relation is off limits? In other words, that woman who cleaned the church property wouldn't be governed by Title VII anti-discrimination laws on the basis of race, the Equal Pay Act, the Fair Labor Standards Act, and so forth. And the Solicitor General of Pennsylvania said, no, we would not agree that individuals in an entirely secular position are exempt from all those regulations under the church autonomy doctrine. Louise, this is the big question that was percolating between the majority and the dissent in the Hobby Lobby case. Justice Ginsburg said the logic of the majority recognizing this exemption means that organizations will seek total exemption from anti-discrimination laws, banning discrimination on the basis of race and sexual orientation, even for their secular employees, and that will mean the end of anti-discrimination laws. So what does Justice Alito's question tell us about whether this case is likely to grant organizations broader autonomy to give their secular employees, to fire them, for example, for being gay, or not to abide by general anti-discrimination laws?
So I'm just going to do two things. I'm going to talk about a couple things. So one is when we think about what I'm going to call the house of worship exemption that was in the regulation originally. I just want to invoke Nelson Tebby, who did a SCOTUS blog video chat and was talking about a different way to think about that. And one is that I think that may have been adopted really as almost as a policy matter, as a way of saying, we think that this may be a way of accommodating religious objections and doing minimal harm on the theory that most often, and you heard that, I believe, from Paul Clement, people who work in institutions, houses of worship, often share an affinity or at least understand maybe what the job is. There's not a perfect match, but that's one thing. That's very, very different from saying any employer in any university without having to file anything or have any kind of inquiry under the Religious Freedom Act can then provide a wholesale exemption for their employees, period. Very different degrees of harm, very, very different contexts, very different understandings about how we think about institutions. I don't know what we know, then going to your question, Jeff, your more direct question, what we know is if we look at the cases all around the country now, we see the same command or the same call for exemptions from non-discrimination laws. That's what we saw in Masterpiece Cake Shop, with the cake shop saying it's against my religion to have to sell the cake to a gay couple in the same way I would sell a cake to a heterosexual couple. We see coming up in Fulton, the case that the court will be hearing in the fall, Catholic Social Services saying we should be exempt from the requirement that we not discriminate in screening families for foster care because of our religious beliefs. That one's a little bit different because that's a government funded, that's a government service that they're providing. So the question is coming up all over the country in many occasions. And I think what that may be, I think one reason why the justices were focusing so much on whether the ACA could authorize this. If they focus on whether the ACA authorizes this rather than whether RFRA authorizes this, maybe that feels like they're stepping, it would be they're walking a little bit less into that debate. Justice Alito in the Hobby Lobby decision went out of his way to say the fact that we have said that you need to have the accommodation here and that the existing rule didn't satisfy RFRA, went out of his way to say, well, that doesn't mean that that would be our conclusion in a case of a race discrimination case in employment, or perhaps in terms of some other healthcare context. So I think, as with often is the case, we'll see in terms of what the decision says, in terms of on what grounds they rule, and then the language with which they speak about those grounds. But what we know is this is one of the critical contests in our culture and in our courts right now, which is how to, the conversation between advancing equality principles and the tension that that is creating with some really institutions that are asserting a religious objection. The cases are about institutions. They're not about individuals that are really rising.
Thank you for that, and that puts it well. Helen, what light does this oral argument we just heard cast on the different justices' approach to this very broad and crucial question that you've both identified, namely the balance between the interests of individuals in being subject to anti-discrimination protections and the interests of institutions in having religious autonomy? Can you sort of map out the various justices' position? And to begin with Justice Alito, was he suggesting that the church autonomy doctrine would allow, say, a parochial school to fire a teacher for being gay or marrying a man, what light could this decision, whether it's decided broadly or narrowly, cast on this central question in our culture wars?
You know, I don't know if Louise will agree with me on here, but she might. I'm not sure this question of institutional church autonomy is going to be a big part of the decision. They're having an oral argument next week about 2 Catholic schools in California and whether religion teachers are included as ministers so that the church has the autonomous right to hire and fire them. I think that's going to be a big feature of next week. I think Justice Alito was asking about institutions for the purpose of pinning the Attorney General of Pennsylvania to a point, not because this case will advance that. I think the more interesting thing about this case, one, and again, I think it was Justice Alito, wasn't it, who kept asking the question, why did the Third Circuit disagree with our description of the start of a free exercise case, whether institutional or individual, which is what's a burden? And I think Justice Alito wanted to lay down his marker, and I think he's got at least 5 members of the court with him on this, to say a burden is not something we're going to look behind. And if someone looks to be sincere, then if they say that a particular practice or government mandate is a burden, we're going to go along with that. So I think he was signaling that we're not changing from Hobby Lobby on that one. So we know that aspect of the free exercise case. They didn't talk about the state's compelling state interest here, not at all. There's a lot of talk about it in the briefs, but not in the oral arguments. They talked a little bit about the third prong of a free exercise claim under RFRA or the Constitution, which is the question of the least restrictive means, right? Is the state using the absolute least restrictive means if it does want to provide contraception to these group of women who will not get it through their employers? I was kind of surprised that the government didn't come back and remind the court that since the Trump administration's new rule, they have allowed Title X programs, which are these federal programs in the states, to provide any woman who can't get contraception from her religious employer to get it through these other services. And besides, if you actually look at the data, women were getting contraception as much as they wanted. They'd really reached sort of maximum capacity. The poor get it for free. Middle-class women and women with even more money were almost completely getting it through their employers. So there wasn't this big sense of urgency for this mandate. There hasn't been before Obama's rule, during Trump's rule, or today, So there was just no real urgency about it, but I'm surprised that Noel Francisco and Paul Clement didn't talk about that.
Thank you for that. Well, Louise, we've talked about one way that the court could rule in favor of the Trump administration's moral objection by saying that the statutory language authorizes it, and as long as the rule is reasonable and not arbitrary and capricious, then a court should defer to that. What would be a way for the court to rule more narrowly against it? Is there some way, if the Chief Justice were inclined to find an accommodation, as he repeatedly said that he wanted to, that he could do so? And what would that opinion look like?
So I'm just going to go back just for one moment to what Helen was saying in terms of whether there was an urgency for the contraceptive mandate in the first place. I think we all know the data that says that most women during their lifetime use contraception. That's a very different proposition from whether women can continuously use it and whether they can access the contraceptive of their choice, as opposed to the contraception that they can afford. So there was ample evidence about what it means to be able to pick the method that you think is best for you, including ones that may be more expensive and turn less on sort of our human ways in terms of remembering to take a pill every day, and what the consequences of that are for unintended pregnancies. And we also know that the court has spoken robustly about the importance of being able to control our reproductive health decisions for purposes of equality. So this measure was animated by and understood as essential for health and equality, as a non-discrimination provision. I had a moment listening to the chief and wondering, somehow they're going to be like a Zubik 2. At the end, after that argument, it was, I think, probably a little either like a surprise to all of us or not a surprise in any way to any of us that the court in that decision said, we want you to go back and look at this again. And both the chief and I think it was Breyer who were sort of coming back to say, isn't there some other way? I think they really don't. I very much want to think that behind the chief's question was a desire that the issue not be that there is a complete exemption in this way without attending to women and the access to the contraception that the ACA was designed to afford.
Thanks so much for that. Time for brief closing arguments. Helen, can you imagine some sort of compromise decision? What would it look like? And then in conclusion, tell our viewers why you believe that the court should rule in favor of the Trump administration's regulation allowing employers to opt out of the contraceptive mandate if they have a moral objection to providing it.
I don't think we will get a Zubik 2, though I totally understand Louise's intuition about that. I think this will turn more on whether HHS had the discretion that it usually has to look into something medical, to issue a medical opinion, and then to have religious exemptions, which it does on many types of procedures. I think it would be a really twisted non-textual reading of the Affordable Care Act to say that the HHS did not have this discretion. I think if you, there will be more in the opinion than there was in the argument about the fact that poor women get contraception free, women who can't get it through religious employers now have access to it free or at very low cost through Title X, and other women, the vast majority already had it in their insurance and were easily affording it. I think it will probably come down on the side of the Little Sisters on the grounds of the right to issue this regulation. And it will be really interesting to me if they do not get into the necessity of this accommodation under RFRA, which is what I actually thought this case was going to be mostly about.
Fascinating. Thank you so much for that. Louise, last word to you. Why do you believe that the court should rule against the Trump administration's moral exemption from the obligation to provide healthcare contraception?
I'll just say I do agree with Helen that I think there's a good chance this could be an ACA interpretation case, and remain surprised at how little conversation there was about whether RFRA required this. I continue to take the position that we've taken religious freedom gives you a right to your beliefs, but it doesn't give you a right to discriminate and harm others. And at the end of the day, when we think about non-discrimination provisions, we have to think about what the harm is that's coming here. I'm going to go back to, by virtue of saying, if you have a religious objection to this, you can avoid giving this benefit to your employees at all, as opposed to what we had before, which was you could say you objected and the government and your insurer paid. To say that you don't have to, that the government is saying we are going to recognize your religion in that way at the expense of your employees and wholly deny them the coverage, is to say that those employees are being required to pay for your religion. And that is not where we have been as a country and not where we should be.
Thank you so much, Helen Alvaré and Louise Melling, for an illuminating and rich discussion of the very complicated and important arguments in the Little Sisters case. Helen and Louise, thank you so much for joining. We're going to say thank you and look forward to seeing you soon. And now I'm going to introduce our next panelists for the next case. Here they are. I just have to pull up their bios, and here we go. So we are now lucky enough to be joined by Scott Nelson and Robert McNamara. Scott Nelson filed a brief in support of the President of the United States, who's the petitioner in the second case we heard, which is Barr versus American Association of Political Consultants. And he filed his brief on behalf of Public Citizen and the Public Citizen Foundation. Scott Nelson is an attorney at the Public Citizen Litigation Group in Washington. He's been there since 2001. He's a former law clerk for Justice Byron White on the US Supreme Court, and we are honored to have him today. And Robert McNamara is a senior attorney with the Institute for Justice, and he has filed a brief in support of the state of Pennsylvania, who's the respondent on behalf of the Institute for Justice. He's been with the Institute for Justice since 2006. He litigates constitutional cases protecting free speech, property rights, and economic liberty, and we are honored to have him as well. Thank you so much for joining us, Scott Nelson and Robert McNamara.
Thanks for having me.
Thanks. Let us begin with the basic arguments in this case is about robocalls. And there was that great moment in the case where Justice Breyer dropped off the phone and then he said, I'm sorry, I got a phone call. It wasn't a robocall, but it just reminds us of the fact that our cell phones are treated differently than our home phones. And I know that I've unplugged my landline because I get all these robocalls from the person who had my landline 10 years ago is in a government debt collection agency, and that person I continue to get calls on that person's behalf because those calls are authorized on landlines, but they're not authorized on cell phones. And a central question in this case is whether it was a form of content discrimination for the Congress to say you can't make those government debt collection calls on cell phones, but you can on landlines. And the case was brought by a political action group that said that their political speech was being discriminated against by not being able to make those calls. So Robert McNamara, the respondent, goes first here. So tell us how you see the central issues in the case and how you believe the court was framing them.
Sure. So the central issue in the case is that Congress has made it generally illegal to make robocalls to cell phones, which, huzzah, all of us hate robocalls. But not all robocalls are illegal. If you're making the robocall to talk somebody into paying back their certain kinds of federally backed debt, that's allowed. And so the argument is that's a content-based restriction on speech, right? Like if I am allowed to call you and say A, but I'm not allowed to call you and say B, that's a restriction based solely on what I'm allowed to say, and content-based restrictions on speech get strict scrutiny. And I think most members of the court generally seem to accept that. Justice Ginsburg started her first question with, I have no idea how you get around the content-based question here. But there's a second question sort of lurking in the background that took up a lot of time, and I think rightly so, because what the lower court did in this case is said, okay, well, I'll grant you that this is a content-based restriction on speech. And so what I'm going to do is I'm going to strike down the exception to the general rule. I'm going to say, now the law applies to robocalls that are debt collection calls as well. It applies across the board. And the problem with that is that's not usually what we do when we deal with discriminatory laws. You know, as the chief said at argument, what we usually do is we enjoin the part of the law that violates the Constitution. And there's nothing that violates the Constitution about not prohibiting debt calls. What violates the Constitution is preventing these political groups from engaging in political speech while also allowing people to engage in that same speech as long as it's about debt. That's what violates the Constitution. And so we should enjoin that. And that really, I think, is the most interesting part of this case, because it goes a lot beyond the boundaries of just robocalls. Like at bottom, a lot of constitutional law is about one kind of discrimination or another. You know, in the First Amendment, we say, you can't enforce this law against me because you're not enforcing it against similarly situated people who say different stuff. That's discrimination. But you could also say you can't enforce this law against me because you're enforcing against me based on my race, or you're not enforcing against anyone. You're only enforcing it against me because you don't like me. That's discrimination. And what courts do in all of those situations is they say, if you're right, they say, you're right. That's discriminatory. The government can't prosecute you. They can't do this to you. They don't say, well, you're right. The government better go round up some people of a different race. The government better go round up some people to enforce this law against, and I'm going to let this prosecution go forward. And the remedy below really turned that on its head and said, okay, Congress wanted these people to be able to speak. They wanted debt collectors to be able to speak. We're going to order the executive branch to go out and stop them without sort of making Congress make that difficult judgment in the first instance. And that's a lot of what you see the court really wrestling with, is what the remedy is, what you do with the fact that this is pretty clearly a content-based law, and how the courts go about fixing it. Is it the court's job to rewrite it, or is that Congress's job?
Many thanks for that. So you've identified two central questions the court was just confronting. First, does the law violate the First Amendment? And is it a content-based description? And second, if it is, what's the right remedy? Should we just take out the exemption for the debt collectors, or should we strike down the entire law? Now, in a very injudicious spirit, I've reversed the order. The petitioners should have gone first before the court. The Deputy Solicitor General, Malcolm Stewart, was arguing on behalf of the government. Here, Scott Nelson, you are arguing on behalf of the petitioners, on behalf of Public Citizen. So with apologies for reversing the order, but that'll keep things interesting. Perhaps you could give us a sense of what you heard the court's answer to those two questions. How is it grappling with the question of, first, is the law a content-based discrimination? And second, what should the right remedy be?
Well, as to the first question, I think it's important to start out by giving a little bit of background on what the law is. It's called the Telephone Consumer Protection Act, and what it does is prohibit the use of a particular kind of device, an automatic dialing system or a recorded message, to make calls to cell phones. And that in itself, everyone agrees, is neither a restriction on the content of speech, nor does it prevent anybody from talking about any subject. The problem that the plaintiffs have seized on is that Congress, about 25 years after first enacting the Telephone Consumer Protection Act, created an exception to it that allowed calls made for the collection of government debt or government guaranteed debt. And that's the basis for the argument that the other side has now made, that suddenly this restriction, which was just a restriction of conduct, of the manner in which you place a call, the technology that you use, has become a content-based limit on speech. And the government's first answer to that is it's still not a law that singles out speech for regulation based on its content. What it is, as I think Justice Kagan sort of put her finger on it in one of her questions, is a regulation of a particular type of economic activity, debt collection, and a regulation of what means can be used to engage in that sort of economic activity. And as Justice Breyer pointed out, regulation of economic activity doesn't usually get heightened scrutiny under the First Amendment. But I've got to admit that a lot of the justices, and Justice Kavanaugh was very straightforward about this too, are kind of hung up on the idea that if you have to look at what is said in the call to determine whether the restriction applies, then that may mean that it's content-based. So that then leads to the next question, which is, in the jargon of lawyers, severability. And it's become kind of a theme in a lot of the cases that are coming up in the end of this term and the beginning of next. What happens when you have a law that otherwise is perfectly fine, but it gets some small provision added to it that suddenly arguably makes it constitutionally problematic? Do you strike down the whole law, or do you just segregate out that piece and say, okay, this is the problem, and we're gonna just say this little piece of it is unenforceable, but the rest of it can go forward as is? And you know, what was interesting in today's argument, the challengers to the law argued that that principle can't really be applied if the consequence is going to be that the law is going to regulate more speech. But they got pushback on that, I think, from across the board. And one of the really fascinating things about this new format is, for the first time in 30 years, we get to hear what Justice Thomas is thinking about a lot of these cases. And he asked, I think, a very incisive question to the lawyer for the challengers. You know, he said, really, you know, isn't your argument here that the problem with this law is that it's got this provision that that discriminates in favor of this aspect of the speech? And if that's the problem, why don't we just excise that piece of it? And I think we heard a very upfront statement from the Chief Justice also about how it would be to Congress if this one provision that was. So I think the court seems to be headed toward a focus on that.
Thank you so much for that, Scott. We were just losing you at the end of it, but I did hear you. But thank you for calling out the importance of Justice Thomas's question about the right remedy and the Chief's response that ordinarily Congress proceeds category by category. Why should it have to do everything here at once? Robert, I'll ask you about Justice Thomas's question. He also noted the privacy interest is greater in a landline than in a cell phone, and that severing the law wouldn't give anything to the respondents. It would take speech away from them, but it wouldn't give them the problem that they sought. First, as a privacy guy and a cell phone guy, is it really right that the privacy interest is greater in a landline? I'm more irritated in calls to my cell phone, which I carry around with me at all time, rather than my landline, which I've unplugged because of all the robocalls. So why couldn't Congress treat cell phones and robocalls differently? And then more broadly, delve into this question of severability, because it was crucial to the respondent's position. Justice Sotomayor at the end said, well, maybe we could just include you, the political groups, but not strike down the law for everyone else. So lay out the various possibilities in your view for how the court could come down on severability.
Yeah, so I think privacy is an interesting word to use to describe what the government is really trying to do here. I'm not sure it's privacy. It's not that people are getting information about me that I don't want them to have, which is usually what we mean by privacy. I think really a better word for the harm the law is aimed at is intrusion, right? Like, we don't want to get the robocalls. The robocalls annoy us. I'm not mad that that these people have my phone number, which is privacy. I'm mad that they're using my phone number and bothering me when I'm trying to put my kids to bed. That's intrusion. And I think the response to the idea that, this is just Congress sort of opening up speech on a slow categorical basis is that government-backed debt is not the least intrusive kind of call. Like if you want to rank the level of annoyance people feel when they get robocalls, calls demanding that they pay their student loans are probably much more annoying than calls asking them to contribute to a local civic association. Like those are just not as agitating a phone call. And so it suggests that that's not what Congress is doing. Really, Congress is kowtowing to certain powerful interests and favoring that speech over other speech in a way that historically the court has been skeptical of. If you want to suppress speech, you should suppress everybody's speech. And if you start letting up on the speech you like, on the speech that is going to get some money for you, on the speech that has a more effective lobbying group, that starts to suggest that maybe you're not as serious as you thought you were, or as you say you are, about the interests at stake. And that starts to make us skeptical. And coming to the severability point of what you do with this, I do think Justice Thomas's question gets to the heart of it, though. One difficulty in kind of watching arguments in this format is that it makes it harder to read tea leaves. In live arguments, you can kind of say, oh, the chief didn't have any questions at all for this side. That probably means that the chief favors this side. He was persuaded by their arguments because he didn't say anything. With all of the justices asking questions of both sides, it's kind of unsurprising that the justices have hard questions for both sides because they're really smart and they just ask the hardest questions they can think of. And that is, I think, the crux of the case. The problem with the law is this one little thing. Why not excise the one little thing and just make the government punish more people? And the answer to that, again, goes back to the chief's first question. And I think part of it is there's a problem in how we're talking about what courts do. We keep saying, even in this conversation, that courts strike down laws. But courts don't strike down laws. Courts don't rewrite laws. The law is still there on the books. What the court does is issue orders. And the court has, if this law is unconstitutional, it has two orders it can issue. It can say, you're not allowed to enforce this law against these people. And I think Justice Sotomayor may well be right that in terms of the remedy framed by a district court can say, I'm enjoining the law as to the plaintiffs in front of me, and I'm not going to enjoin it as to anyone else. That's usually a discretionary question. But it can issue an order saying you're not allowed to enforce the law against these people, or it can issue an order saying we insist you enforce the law against these other people who aren't in court, who have not participated in this process. We're going to demand that you go arrest them, go enforce a law against them. That Congress didn't want to enforce against them. And that's an astonishing order, right? Like that's not usually what courts do. And so I agree, if you're sitting down and just sort of thinking about the law from the standpoint of legislative draftsmanship, what you'd probably do is get rid of the small exception. Like that's what I think a reasonable legislator would do. And both the chief and Justice Kavanaugh sort of alluded to this, that everyone hates robocalls. This is a super unpopular law. Isn't it obvious that if Congress had the choice, or that Congress would choose to ban all robocalls? And I think that's probably true, but that's Congress's job in the first instance. The court's job isn't really to sit down and rewrite the legislation. The court's job is just to issue an order. And the general rule is that the order is an order saying you can't enforce this law against these guys in this circumstance. The order issued by a reviewing court is not, you must go forth and take away rights from third parties not before us.
Thank you for all that. Thank you for identifying the harm in this case as being not privacy in the abstract, but a kind of intrusion on seclusion of our homes or our persons, now that we carry the cell phones around with us. Justice Brandeis, in his famous article on the right to privacy, identified a series of privacy interests, including intrusion on seclusion, false light, intentional infliction of emotional distress, and speech that infringed our dignity by being outrageous and highly offensive to a reasonable person. Scott Nelson, we heard Justice Brandeis invoked by Justice Breyer, who talked about his third category of economic speech, which generally was less closely scrutinized than other speech. But Justice Brandeis, of course, in his famous article, identified a tension between protecting privacy and protecting speech, and eventually changed his mind and concluded that too strong protections for privacy would infringe free speech. My question is, Justice Breyer, he said, I have a philosophical question. What is content discrimination? All human life is carried on through speech. All government regulation is carried on through speech. Every statute book is filled with content discrimination. I always thought that was in Justice Brandeis's third category of economic regulation, as far as that's concerned. So what was the implication of his question? And would holding otherwise, that regulation is subject to a higher degree of scrutiny whenever it makes content discrimination, would that call many forms of regulation into question?
Well, that is in fact what corporate interests have been doing now for several years in light of the court's broad statements in some cases about the meaning of content discrimination. They've challenged all manner of restrictions on commercial activity that is, as Justice Breyer explained, carried out in part through communication, such as the offering of securities, for example, is carried out through speech. But it's usually been regarded as something that's fair game for government regulation, even though those regulations wouldn't apply if you were talking about hamburgers rather than securities. And I think that's what Justice Breyer is worried about, and we have seen in a host of cases that commercial entities that are resisting economic regulation have made that argument. The lawyer for the challengers in this case said, well, that isn't a problem because as long as you're only regulating commercial speech, content-based discrimination is just fine. I actually agree with that specific statement. Unfortunately, a lot of commercial speakers who are trying to evade regulation have been challenging that, and they've been relying on the same line of cases that the challengers are relying on here to try to characterize economic regulation as speech regulation. And, I think this is really a case in point. I mean, this is not about saying that you can call somebody if you're advocating on behalf of abortion rights, but not if you're advocating restricting abortion. What's being said here is a particular form of technology can be used for one particular commercial activity, debt collection, and it can't be used for other calls. Now, I happen to agree with Robert that particular exception is a very bad idea as a policy matter. I'd be much happier about this statute if it didn't allow government debt collection to be carried out through robocalls. But not everything that I disagree with on a policy matter is unconstitutional. But even if it is, which is the point here, I want to push back a little bit against the idea that it's not what courts do to tailor their remedies to the scope of the aspect of the statute that is constitutionally problematic. In fact, the court has repeatedly insisted that when dealing with a challenge to the constitutionality of the statute, you don't just look at the relief that the particular plaintiff wants. You look at what Congress would have intended this to be enforceable if this one particular aspect of the statute did in fact raise a constitutional challenge. And so here, what a court would do, to put it in Robert's terms, is it would issue an order saying, yes, this statute may be enforced as long as this exception is rendered inoperative. Courts actually do that quite frequently. There was a case a couple of years ago where someone came into court challenging an immigration law that favored the children of women citizens who were born overseas over the children of male citizens. And the court said, yes, that's unconstitutional, but the challenger, who was the child of a male citizen, was out of luck, because what the court actually said was, we're going to remedy that by saying that the preference that has been given to the children of women citizens is what's invalid. And so you don't get any relief, and neither do the children of the women, and now everyone's treated equally.
That's precisely right. Thank you so much, Scott, for showing us the range of options the court faces in deciding remedies. Justice Ginsburg, when she was an advocate, often cited a case by Justice Harlan, which said that when there's a violation of equal protection, the remedy is either to extend the benefit to the excluded class, if men are being discriminated against, you can extend it to men or to women, or to strike it down for everyone. Robert, is that a version of what the court faces here, whether to extend or to exclude? And what is your response to the Chief's very stark question? He said, no one wants to get calls on cell phones. The idea that Congress would want us to strike down the whole law to save the government debt exception, well, that would make them even more unpopular. And obviously they didn't want that.
Yeah, so there is a line of cases that says when you're talking about a government benefit, the court's remedy can be either extending the benefit or eliminating the discriminatory benefit. But I do think there's a difference between cases about government benefits, where you're either extending them or removing them, and cases about punitive laws, cases that restrict individual liberty. And I think it's a stretch to say that courts routinely do this. The immigration case Scott is talking about is the only time in many decades that we see the court doing that. And Justice Ginsburg's opinion in that case is very clear that the only reason that she's leveling down instead of leveling up is that leveling up would actually be insane, would create a situation that is so unthinkable it would be unconstitutional on its own merits. So it's not something courts routinely do, is issue an order that says, go forth and punish more people. And it would be an unusual remedy in this case. And I think the Chief is probably right that nobody in Congress would want to say it's a free-for-all for robocalls. But I also think that it's Congress's job to say that in the first instance, that usually it's the legislature's job to restrict liberty. It's not the court's job to say you haven't restricted enough liberty. We are imposing by fiat greater restrictions on liberty. So I think that's ultimately the outcome of the severability issue. And just to address a little bit the speech conduct question that Scott was talking about. It does come up a lot in both, you heard it from Justice Kagan and you heard it from Justice Breyer, this idea that what the legislature is trying to do here is regulate economic activity. And there's this sense that perhaps the fact that it's economic activity should swallow the fact that it's speech. And I think that's an intuition a lot of people have, but it's not an intuition that I think really holds up on close examination. I mean, all three of us right now are getting paid to have this conversation, and yet all three of us are talking. We all have jobs. We're all doing this in the course of our jobs. I didn't get an honorarium, but we all have jobs. If we can
get paid, that'd be great.
But that doesn't change the fact that what we're doing is talking. And what the court has recognized in its modern jurisprudence is that you can always kind of play this game when you're talking about First Amendment cases, where the government can always say it's trying to get at some underlying conduct, because everything's conduct in a sense, right? Like writing an article is pounding your fingers on the keyboard. The government could say that we're not trying to suppress speech urging you to go on strike. We're trying to stabilize the labor market. Stand-up comedians don't just tell jokes. They engage in the conduct of inducing amusement. And what the court has said is we don't care what label the government puts on it. We need a broad protection of speech. And the way you protect speech is you say, if the thing that makes what you're doing illegal is simply what you're saying, then that's a content-based restriction on speech. If all the other things you're doing could be held the same, and if you just say something different, it becomes legal or illegal, that's a content-based restriction on speech. It is the simplest test in the world. And I think the efforts of the government to muddy the test and make this seem difficult are really just an effort to pare back First Amendment protections across the board. You protect free speech by protecting free speech.
Many thanks for that. Scott, one last substantive question and then brief closing arguments. You referred to a broad effort to strike down government regulations as a violation of the First Amendment. Some have called this economic First Amendment Lochnerism after Lochner versus New York, the 1905 case that struck down maximum hour laws for bakers on the grounds that they violated freedom of contract. The claim here is that by closely scrutinizing economic regulations as violations of free speech, the court is once again second-guessing legislative judgments. Can you, based on this argument, give us a sense of which justices, if any, are sympathetic to this very high protection for speech and for closely scrutinizing economic regulations? Who's on the other side? We know Justice Breyer is in favor of great deference. And is Chief Justice Roberts somewhere in the middle when he referred in his very first question to this Reed case, which basically said that we have to ask whether the law targets speech based on its communicative content, and it's a case-by-case evaluation?
I think, you know, to begin with, the justices who are most suspicious of the encroachment of the First Amendment on economic regulation are pretty clearly Justices Kagan, Breyer, and Ginsburg, and Sotomayor. The justices that I think have in other cases been on the opposite side of that are Justices Thomas and Alito and Gorsuch. I think we don't have that good a sense yet of Justice Kavanaugh on this matter, but I think that he and Justice Roberts are probably to the extent that there's any swing on the issue, they would be a little bit more toward the center of the court. However, in this particular case, you heard Justice Kavanaugh pretty straightforwardly say in response to a question that he saw the case as principally being about severance because this looked like a content-based restriction to him. Justice Roberts, I think, asked some questions that suggested that he wanted to hear the arguments on both sides of that issue and was kind of pressing, I think, both sides on the point, at least to some extent, although, again, for him, the pressure point on the challengers seemed to be the question of severance more than the question of whether this was content-based.
Thanks so much for that. Well, time for brief closing arguments in the spirit of the oral arguments we've just heard. And we've covered the two main legal arguments so well. First, is it content-based discrimination? And if so, what's the right remedy? That I'll just ask a very basic question. Why is this case important? And why should our great C-SPAN and National Constitution Center viewers care about it? And Robert, the first closing argument is to you.
This case is important not because it's about robocalls or because any of us need to have any sympathy for the ability of anyone to make robocalls at any time. This case is important because it is part of a broader argument about what the First Amendment means. And with respect, I disagree that what we're seeing is the First Amendment invading economic regulation. What we're seeing are economic regulations invading free speech. And the mere fact that someone engages in speech as part of an economic transaction doesn't obviate their First Amendment rights. People have economic expectations and economic interests all the time. The best-selling book in the country is the Bible. The Bible remains protected by the First Amendment, notwithstanding the fact that people buy and sell it for money. And I think what we're seeing is a broader recognition that the First Amendment means what it says, and we don't need to interpolate into the First Amendment extra exceptions that let the government get away with more than we would just because we're worried that the people who are engaged in the speech are also engaged in earning an honest living by speaking.
Thank you so much for that. And Scott Nelson, the last word is to you. Why is this case important, and why should our great viewers care about it?
Well, I guess I would take issue with Robert on his first point. I think this case is very much about robocalls, and Robert said earlier, and I agree with him, that if it would be insane to strike down an entire statute rather than just the little part of it that makes it unconstitutional, then that would be the case where the court would excise the small portion. I think it would be insane to say that robocallers have free rein to invade our cell phones without restriction, merely because Congress, 25 years into this very important consumer protection statute, added this provision, which at best is ill-advised and according to the challengers in this case is unconstitutional, but doesn't render the basic project of this statute, which is protecting the privacy of Americans against a very intrusive and obnoxious technology. It doesn't render that whole project unconstitutional. And if we're stuck with unrestricted robocalls as a result of Congress's addition of this exception, that would be a result that would be bad for everyone in this country.
Thank you so much, Robert McNamara and Scott Nelson, for a vigorous, full, and illuminating discussion of these crucial First Amendment issues. Dear C-SPAN friends, National Constitution Center friends, thank you for joining during this exciting educational experiment this week. For the first time in American history, the Supreme Court broadcast live oral arguments, and you joined along with us, carefully digging in to the oral arguments and trying to make sense of them. It required some homework on all of our parts, didn't it? We had to listen closely to these arguments. I hope you followed my stern exhortation and did some homework by reading the briefs in advance, which is really the best way to understand the arguments. And then we had these really thoughtful discussions afterward where you listened to the arguments on both sides and tried to make up your own minds. I have emerged from this first week of our experiment with renewed respect for the rigor and complexity of the court's deliberations, the seriousness with which it conducts them, and the need for all of us really to take time to educate ourselves about these crucial cases so that we can have informed opinions about them. Your homework over the weekend is obvious. Read the briefs for next week's cases. And there are important ones involving presidential subpoenas, more cases involving religious liberty. You'll have to set aside some time for it, but I know you can do it and you will. Also, go to the great educational resources of the National Constitution Center. Our interactive Constitution brings together the top liberal and conservative scholars in the country to write about every clause of the Constitution, describing what they agree about and what they disagree about. And it is such a font of light and constitutional learning to have access to this free tool. And then there's the We the People podcast that I host every week, which is just in this very format. In fact, we'll be running these discussions as part of the podcast where I call up a liberal or a conservative scholar on both sides of crucial constitutional issues in the news. And we have the sort of reasoned civil discussion that you've just heard today. So for providing a model of constitutional discourse and for spreading much constitutional light in the spirit of Justice Brandeis, who we heard mentioned several times today, I want to thank Robert McNamara and Scott Nelson, and let us end with the inspiring words of Brandeis: if we would govern by the light of reason, we must let our minds be bold. Robert McNamara, Scott Nelson, thank you so much for joining. Thank you, C-SPAN viewers, and look forward to seeing you next week. Bye.